We are here in the matter of Archie versus Bugs. Ms. Ortega, is there anything you'd like to add to your motion?
Yes, thank you, Your Honor. As I stated previous, just going on the record, my client is not here today. He's in a part of a country where he can't appear by Zoom. He was going to try. However, we didn't want to delay this motion for a different day because we've already delayed long enough, thinking that we were going to be discussing potential settlement. But after we adjourned our hearing, it was crickets for a long time until we filed this notice of hearing.
It's okay.
You said you have several notes on this, so I'm not going to belabor my argument, but just as noted, my client was, and I'm going first on the recommendation. I want to make sure that the court received our motion regarding custody and parenting time as well. When I look at the register of actions, it just shows an objection hearing today. So I wanted to make sure.
No, I've got both on my docket. That's why I've got several pages of notes. Well, not several pages. I've got more notes on this case than some of the other cases.
All right. Thank you, Your Honor.
Because I had to do some research on this one myself.
Okay. My client did not receive, while it may have been emailed, he did not receive the actual report and recommendation. The court knows that he filed his objection delayed. He actually filed objection after receiving by mail the signed order. And so that I'm requesting that either there's leave to allow extension on that objection, or you treat the objection as a motion for reconsideration after that order. So my understanding, in the really big thing we're arguing, is the number of overnights on that order. My understanding that Mystics does not deny that he does exercise a lot more than 60 overnights a year. We did an average of 120. My client believes that it's more than that, but we think 120 is fair. So on that, we're asking the court to amend that order, utilizing the same information except for the overnights to be adjusted to 120, and that to backdate to the start of that order. And then for our motion for custody and parenting time, this is court. This is similar to a Sims versus Verbrugge situation where there is no joint, or there's no legal custody in any of the orders yet. So we're asking for joint legal custody. And then as far as physical custody, it was just a default judgment, no best interest factors were ever considered, no evidence as to that. And what has happened is primarily the parties have been able to work together for several years. And so there really was no need to litigate those issues. My client was kind of hinging on promises that there would be increase in time as the child got older. Those just kept getting delayed and delayed and delayed. And so, and then after this friend of the court order, the 60 overnights are there. And then the realization that, well, there really is no order for parenting time. Then we started getting, or my client started getting, well, no's, you can't have her, we're not going to do this anymore type situation. And then the parties between themselves had talked about, okay, we understood there to be an agreement to a step-up schedule to like a shared parenting time 50-50, and then that would be retracted, then it would be promised again. And so I don't really believe that there is an issue with the parties sharing joint legal and joint physical custody. However, at this time, clearly there's an objection to it legally. And so we would ask the court to send the issue to the front of the court on custody, parenting time, and then child support review in the event that there is an increase above the 120 overnights. My client has participated in schooling. He has participated in conferences. He has participated in decisions for the child. The one thing he hasn't participated in is concerning is that Mystics enrolled the child in counseling, and she won't share the information. Even through counsel, I still have not received the information for the counselor. And so we believe that to be relatively new. We would like that information. And then I believe that the Michigan law allows us to enter a temporary order today based on joint legal custody and a parenting time schedule on a temporary basis, because there is none right now. So on a temporary basis, we're asking for the remainder of the summer to be week on, week off, except for any agreed upon vacations they've already agreed on. Last summer, my client had the child for the majority of the summer. So this is not something new to them.
When is he coming back from wherever he's at?
I believe next week, Your Honor.
Okay.
So aside from that, and then when school starts, because we don't believe, obviously, the front of the court's not going to be done, we're asking for alternating weekends, again, on a temporary basis from Friday after school till Monday morning, and then every Wednesday overnight. which I don't believe goes all the way to a joint legal or a joint physical situation. And then alternating holidays, because it seems as though, you know, Mystics, now that she knows, hey, there's no actual order, she's been getting fuzzy. So.
All right. Ms. Hayes, anything you'd like to add?
Thank you, Your Honor. First, I have no objection to the court either treating this as an objection properly filed within the time frame or a reconsideration.
No.
I think what Ms. Ortega outlined for the court as far as the legal custody not being addressed, we're not objecting to that being addressed, but we would, as noted in our response, just say that Mystics has, for the majority of her child's life, exercised that legal custody. As far as the physical custody, again, as Ms. Ortega outlined, it was by default. We have no objection to the court looking at that. However, we don't think it's appropriate for there to be a joint physical situation. Very open to more parenting time. I think Mystic's concern is really that the father is working with the child to develop that relationship. She understands that the child needs both parents and has encouraged the other party to, you know, attend counseling with the child so that they can work on building that relationship and making the child feel more comfortable with it. I think the proposed modification to kind of a week on, week off is kind of drastic for her. And so we'd ask something to be graduated. I know the proposed schedule that Ms. Ortega just outlined isn't quite the week on, week off. We'd asked for whatever increase in parenting time to look at what is actually best for the child so it doesn't completely disrupt the stability in her life. So Mystics is very open to that and encouraging that relationship. So I do think it is appropriate to refer that to a friend of the court. I think the 120 overnights is a little bit high for what has actually been exercised. I think it's probably somewhere between 79 to 90-ish annually. But as Ms. Ortega outlined, obviously, if that changes with any type of parenting time order, the child support order should be modified to reflect that. So we would defer to the court as far as the next step.
You just threw out my notes on half of the stuff on the child support order since both parties are agreeing that could be looked at. But that's what I spent about a half hour researching yesterday was the child support order. So never mind. All right. But it's always grateful to have somebody. So in other words, I would have the child support because I will send this to the front of the court and I will have the child support reviewed all the way back to November 1st. That way it takes care of the request of both parties. Under Sims versus Verbrugge, there is legal custody here. The legal custody is statutory. 722.02, a child born out of wedlock has only one parent, and that's the mother, thus automatically giving the mother sole legal and sole physical custody. Sims versus Verbrugge is a case out of Kent County due to this exact order from the prosecutor. This is what it was all based on. The prosecutor by statute can only deal with child support. They're here generally on behalf of DHHS, and the state wants to collect its share of the child support. That's the only reason for those orders. They have no authority to deal with parenting time, and they have no authority to deal with legal custody. The only reason that they put in physical custody, and it is ordered, default or otherwise, it is ordered under Sims versus Verbrugge itself, that the court has already made a determination as to custody. And the reason for that is, under federal law, you have to have custody outlines so that the person can receive aid. Because the only person who can receive aid is a person that has custody. Thus, that's why the prosecutor has to put that in there. So yes, custody has already been determined, but as you both know, in Michigan, custody is a word. I can grant her physical custody and grant him 300 overnights a year. What matters is parenting time. Pursuant to Sims versus Verbrugge, legal custody can be looked at. I don't need a change of circumstance. So I will send this to the front of the court for legal, parenting time, and child support. Normally I'd tell you that the older the kid is, the harder that legal custody is. This is a 2010 case. We're dealing with a 15-year-old. We're not talking about a 2 or 3-year-old. Normally over time, the established environments of legal and physical establish with one parent or the other. If he's been involved as much as he says, and been involved with the school, and been involved with the physicians and doctors, then he may, because the other step is you have to determine, since change of circumstances is thrown out the window by the case law, because of the way this was entered, and statutory is the only way she has legal, the court doesn't need a change of circumstance to then look at it for a court order. However, you still have to overcome a custodial environment. So if the front of the court finds that there is a legal custodial environment with mother, he would need clear and convincing evidence to overcome that. But Ms. Hayes, she does have the right. You indicated that he knows the counselor, or they've asked him to be involved. Ms. Ortega is of the opinion that they don't know it. I would ask that information be exchanged, because pursuant to the health code, both parties have the right, as long as they are legal parents, whether they have legal custody or not, they have the right to access any medical or school issue. They have the right to contact. They just don't have the right to make any decisions, but they have the right to have knowledge of it and to contact those professionals. So that's pursuant to law in Michigan, that he is the legal father. He gets that right. He needs to know who the counselor is, and he has the right to make contact. This is a 15-year-old. I'm not ordering any temporary nothing. You guys have been doing this for 15 years. You'll continue to do it. I'm not going to, in 10 minutes, jump into your case and then give an order that I have no idea if it's right or wrong for the kid. Week on, week off may sound great, but I don't know. Does she do sports? Does she do anything during the summer? You know, how far apart do the parties live? Would he may be able to make that happen? These are things I do not know. Therefore, I'm not ordering something that's going to affect this child's life right now without all the information that I would absolutely need to make that decision. And heck, I've had 5-day hearings and I don't get enough, let alone a 10-minute argument by attorneys arguing on behalf of their clients. So I will send this to FOC for legal, parenting time, and child support backdated to 11/1 of 23. That way he can make the argument. As you know, up to 70 overnights a year, it does not impact child support. It takes to about 121 overnights to start impacting child support, and we'll see. You know, I don't know how far apart the parties live. I don't know what the child's schedule is, and she's 15. We're talking about interference soon with jobs and boyfriends, both of which can be problematic for both parties. Good
Your
luck.
Honor, if I may,
Sure.
I don't hear any objection or anything to the contrary that my client hasn't been involved. He's had the child overnights and weeknights.
I agree. He should, but I'm going to say continue doing what he's been doing. I'm not sure what that is.
Okay, and that is
Now,
fine.
I'm ordering
My
her
concern
because
is
Miss Dix, and I hope somebody has kept calendars about who's done what and when. It would be nice to know what the history is here. But I would highly encourage you to continue what you've been doing and allowing the reasonable parenting time that is already ordered. It is ordered, reasonable as agreed. Sounds like for 15 years they've had some agreements and have done pretty well. And it sounds like the child is doing well. I'm not hearing anybody say the child's not doing well. Maybe some counseling due to being a teenager. God help us all. We all got through it though, right? All right, so we'll get her through it too. But I would encourage Ms. Dix to encourage that relationship. Don't withhold the child, because that is one of the factors. If you withhold, that can be held against you. So, and if you give him time and he does not exercise it, that can be held against him. Held against him. Let me do proper English here. But in any event, just continue to do what you've been doing. Do it in the best interest of this child. Make sure that both parties, you've got the rest of high school and prom and all these other things coming up that everybody needs to cooperate a little bit better. You've been cooperating for 15 years. I'm not jumping into your life right now and doing something that may hurt instead of help. Okay. So I will send this to the front of the court. It'll be a $150 charge for each party. So I'm not going to waive the charge because they're both represented by attorneys. And then hopefully that'll help. You might be able to get through this easily. They finish 80% of the cases. Luckily, the 80 to 85%, 10 to 15% come back and need court hearings. But you've got two good attorneys on this, Ms. Dix. The father is represented well, and so are you. So hopefully they'll get you through this, and the next 2.5 years, that's all we've got.
Yes.
All righty.
Yes.
So take care of yourself, and I'll send that to the front of the court, and I'll do the recommendation order.
Okay.
Thank you.
All right.
Should I prepare? order, Your Honor, regarding the information on the counselor and then the retroactivity of the child support.
If you wish, I'm going to put it on the recommendation that child support is supposed to start on 11/1. But if you want to back it up, you're more than welcome to.
All right.
I have no problem with suspenders and bootstraps.
I don't think it'll be an issue. I'll contact Ms. Hay.
It probably won't be, but
well to make sure these things happen.
Nice to see all of you. You have a good morning.
Thank you.
Good luck with the rest of the summer, Mystics, and make sure that.
Thank you.
No problem. And maybe you can talk him into taking her wherever he's going next time.
Well, Well, we'll address all of those things.
Yeah,
There's a lot of things that have been mentioned that I just have not, spoken on it. My attorney has done a very good job speaking for me, but there are a lot of concerns.
Well, that's why I'm sending it to the front of the court, and that's why I don't change anything. Because what I also try to do is prevent the mudslinging. I get blamed a lot for talking a lot. And part of it is to help settle the clients, let them know I'm listening and I'm reviewing what they've said, but I'm also preventing them from mudslinging at each other, because once you say something, you can't put it back in your mouth. Absolutely. And the other side has heard it and it reverberates in their head. Yeah. So if I can prevent the two of you from doing something like that, I found that actually assists the cases.
Yeah, absolutely. And I'm not interested in doing that. I'm interested
No, that's okay.
Stating the facts and, the best interests of my daughter. And as you stated, she is 15. And, so it's quite interesting that we're here regarding child support and parenting time and how those things kind of, But thank you very much.
Have a good morning. Good luck. And they'll be contacting you in the next week or two.
Okay. Thank you.
Take care, everybody. Stay safe.
You too. Bye.